Today we're going to talk about the special status Jammu and Kashmir has enjoyed as a state of the Indian Union and how the Narendra Modi government has finally brought that status to an end. What exactly has special status meant for the Kashmiris? This or this or this? Well, in a way, this is proof of their special status, since you don't see these sorts of images from other parts of India now, do you? But that's not the special status I mean, and in any case, that special status is not going to end. No sir, it's not. The special status that's in the news today is Article 370 of the Indian Constitution, which says that most laws and provisions which the Indian Parliament makes can apply to Jammu and Kashmir only if the State's Assembly agrees to them. On Monday, Home Minister Amit Shah dropped two bombshells in Parliament. First, he said the government has decided to scupper the essence of Article 370 by a presidential order declaring that henceforth the whole constitution will apply unconditionally to Jammu and Kashmir. The second bombshell was that the state of J&K, as we now know it, will no longer exist. In its place will come two union territories, one for Ladakh and one for Jammu and Kashmir. Are these moves legal? That's what we're going to be discussing in this episode of Beyond the Headlines. I'm calling this a constitutional coup because there is no other way to describe the measures Amit Shah unveiled. Not only has he assailed the sanctity of a constitutional provision that was brought in to give legal expression to Jammu and Kashmir's accession to India in October 1947, but has also driven a stake through the federal structure of the Indian polity by simply abolishing a state of the Union through a central diktat. That these shocking announcements were preceded by the kind of measures that one normally associates with a police state, the midnight arrest of mainstream political leaders in Kashmir, the prohibition of public gatherings, not to speak of the ouster of all tourists, adds the sort of color one normally associates with coups. Let's address each of the issues of legality one by one. Article 370 did not drop from midair. It was the direct product of a solemn bargain the Union of India struck with Maharaja Hari Singh of Jammu and Kashmir in October 1947. India became independent from the British on August 15th that year, but the princely state of J&K, which wanted to be independent, did not accede to India until after it was attacked by Pakistani tribesmen. Under the terms of the Instrument of Accession, the Maharaja said, and India agreed, that Kashmir would primarily be acceding in respect of defense, foreign affairs, and communications. Since we are speaking of the Constitution, this is what Article 7 of the Instrument of Accession said. Nothing in this instrument shall be deemed to commit me, this is Hari Singh speaking, in any way to acceptance of any future Constitution of India or to fetter my discretion to enter into arrangements with the Government of India under any such future Constitution. So Article 370 was a carefully drafted and negotiated provision that was intended to cement Jammu and Kashmir's place in the Union on the basis of the conditions under which it had acceded to India. While lots of other states have special provisions in the Constitution, there is 371A for Nagaland, for example, which allows legal mechanisms under Naga customary law. But none of those flowed from a legal compact like an instrument of accession. This is the first point to bear in mind. Now, 370 came into being on January 26, 1950, and had provisions for the President of India to extend certain sections of the Constitution to J&K with the concurrence of the state government. Article 370 also said that these would have to be placed before the state's Constituent Assembly, quote, for such decision as it may take thereon, unquote, implying that the state's assembly was actually the final authority as to which parts of the Constitution would apply and which wouldn't. Now, there's a lot of ignorant commentary floating around about how Article 370 is listed as a temporary provision in the Constitution and can thus be done away with. Yes, it could have been done away with, by the J&K Constituent Assembly, which chose not to do so. According to the constitutional expert A.G. Noorani, who has written the definitive book on Article 370, the Article's provisions are temporary in that the state government's authority to give its concurrence to presidential orders lasts only till the state's Constituent Assembly is convened. Quote, once the Constituent Assembly of the state met, the state government could not give its own concurrence, still less after the assembly met and dispersed. Moreover, the president cannot exercise his power to extend the Indian Constitution to Jammu and Kashmir indefinitely. The power has to stop at the point the state's Constituent Assembly drafted the state's constitution and decided finally what additional subjects to confer on the Union and what other provisions of the Constitution of India it should get extended to the state, rather than having their counterparts embodied in the state constitution itself. Once the state's Constituent Assembly had finalized the scheme and dispersed, the president's extending powers ended completely, unquote. Of course, Article 370 does have a provision for amendment. Let's see what it says. Article 373 says, notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications, and from such a date as he may specify, provided, and this is important, provided that the recommendation of the Constituent Assembly of the state shall be necessary before the President issues such a notification. Amit Shah tries to get around this in a two-step process. First, he claims, the presidential order has the power to amend another article of the Constitution, Article 367, and he has thus inserted into the Constitution a redefinition of the Constituent Assembly of Jammu and Kashmir to the effect that henceforth that expression will mean the state's legislative assembly. Having done this unconstitutional jugglery, a presidential order, to my mind, cannot amend an existing clause of the Constitution in this way. Shah then claimed that since the J&K Assembly is currently dissolved and the state is under central rule, Parliament can act as a substitute for the Legislative Assembly and the defunct J&K Constituent Assembly as well. This is a truly breathtaking claim. The J&K Constituent Assembly adopted the J&K Constitution in 1956 and formally dissolved itself with effect from January 26, 1957. As Noorani notes, the language the Assembly chose to describe its demise was deliberate. On January 24, 1950, the Constituent Assembly of India, meeting for the last time, had merely adjourned itself sine die, that is, with no set date for its next meeting. By contrast, the J&K Constituent Assembly resolution on its last day was, quote, today this historic session ends, and with this, the Constituent Assembly is dissolved according to the resolution passed on 17th November 1956. The idea, clearly, was that with the dissolution of the J&K Constituent Assembly, the temporary nature of Article 370 was rendered permanent, since the only body capable of effacing or amending it would no longer exist. This interpretation was upheld by a constitution bench of the Supreme Court in 1959 in Premnath Kaul versus the state of J&K. However, first Nehru and then subsequent governments whittled away at the autonomy of the state, regrettably with the backing of subsequent rulings of the Supreme Court. However, in a more recent judgment, Justice Rohinton Nariman wrote that despite the fact that it is stated to be temporary in nature, sub-clause 3 of Article 370 makes it clear that this article shall cease to be operative only from such date as the President may by public notification declare, and this cannot be done under the proviso to Article 373 unless there is a recommendation of the Constituent Assembly of the state so to do. So, I have serious doubts whether the Amit Shah formula of simply pushing through a presidential order will pass the test of constitutionality. What about the unilateral conversion of the state of Jammu and Kashmir into a centrally run union territory and its bifurcation? Well, under Article 3 of the Constitution, this too is surely not permissible. Article 3 of the Constitution says that before Parliament can consider a bill that diminishes the area of a state or changes its name, the bill must be referred by the President to the legislature of that state for expressing its views thereon. This is an essential safeguard of India's federal system and has clearly not been followed in this case. In Parliament, as I said, Shah invoked the legal fiction that since the J&K Assembly was dissolved and the state is under central rule, it is Parliament which gets to exercise the prerogatives of the Assembly. But just think about how dangerous this logic is. The next time a state is under President's rule, and it could be Tamil Nadu or Assam or Karnataka or any state, Parliament can simply go ahead and vote to abolish that state. Is that what Amit Shah is saying? I find it astonishing that regional parties like the YSR Congress of Andhra Pradesh, the Biju Janata Dal of Odisha, and the Aam Aadmi Party have declared their support for this kind of unconstitutional and anti-federal package. Make no mistake, what Amit Shah and Narendra Modi have unveiled today is not just an assault on the unique place that Jammu and Kashmir enjoys in India, but on the very federal structure of the Indian Constitution. And I expect that the Supreme Court in due course will call the government out on this. Well, that wraps up all that I wanted to say on the legal aspects of Amit Shah's surgical strike on the Constitution. Join me again tomorrow when I will analyze the political, security, and diplomatic implications of the end of Article 370.